All right, what's a motion for summary judgment? A motion for summary judgment is court process for a party. Both parties have the right for motion for summary judge two motions for summary judgment to move the court and based on the claim in said motion to try to get the judge to make a ruling for you to obtain what you seek in your claim, right? So if you're suing for this amount of money, you're filing a motion to say, Judge, there's no reason why this claim should go before a trial by jury. It's a waste of time and taxpayer dollars. I have a preponderance of evidence through perpetual record, testimony, transcripts, etc. Right? So it would make no sense to move this claim to trial because it's clear that I'm going to win it. And then the opposing party would put an affirmation in opposition to a motion for summary judgment, begging to the court why their motion should be dismissed with merit standing and foundation. If not, it'd be a frivolous claim on either side, correct? But you'll have, especially when it comes to attorney generals, they'll try to weasel their way out of it and try to put language in there like res judicata and all kind of things, right? So you beat them with void ab initio. It's little games that are played. You have to really know how to structure a motion for summary judgment, and it's not going to be a 1 or 2 page document. Ain't happening, right? And then when they respond to their affirmation and opposition to dismiss, right, motion for summary judgment, you get to respond. You get to reply to their answer. So you basically get to see their hand, and then you get to pick another card and see their defenses. Now you can bring in your defenses to invalidate the merit of their claim. So both parties have the right to file motions for summary judgment. On the federal level, a lot of magistrates, like they've done to me, will say, well, you got to write a letter to the court and ask them if you can file a motion for summary judgment. And I stated for the record, I object. I'm not going to write the court to ask for permission. It's my right to file a motion for summary judgment, and I can file it at any time. He goes, you're right. I have it recorded. So at any time, a party can file a motion for summary judgment. Some wait a little longer so they can see what the other party has through motion of discovery, through discovery rather, right? So you want to see, you did something right in a lot of state cases or federal cases rather against the state or state municipality, and they're being indemnified by the attorney general or something like that. They know that they're in the wrong, but they have to save face, right? Because it would prove that the municipality is not doing things correctly, and they're the overseers of that, right? So it would show that they're not handling their business. So they have to do everything they can in their power to defend the name to make it seem like they're still doing everything correctly. It's just how it works. It's politics. Don't be naive to think otherwise. And it's just how it works. They didn't become attorney generals to defend them for nothing. But prosecutors and attorney generals also are supposed to work off integrity. Meaning, if you know somebody did something wrong, it is your duty to expose that as well, not for political gain, but for protection of the people, right? So there's a lot of tricks when it comes to motion of discovery when it comes to attorney generals, and they'll file motion for summary judgment as well, and then you respond, and they'll put motions to dismiss. Well, in my case, they never filed a motion to dismiss because the claim was valid, but they filed a motion for summary judgment. Simply objected pursuant to Trinity versus Pagliaro. Hint, hint. Statements from counsel during argument and brief are not sufficient as trial evidence. I apologize for summary judgment, right? But motion for summary judgment is a powerful tool to put put the court on notice to say, listen, there's no reason that this should go to a trial by jury. Why waste the taxpayer dollars when the same thing I'm proving in this motion for summary judgment, I'm going to prove in a trial and embarrass this wrongdoer or the accused that I'm accusing or suing or have my claim against. on the record? Why would they not save themselves from the public humiliation? And a judge can grant you summary judgment or partial summary judgment. And if you don't agree, what can you do? You can appeal the decision. And my motion for summary judgment, I also, or response to a motion for summary judgment, this isn't legal advice. I suggest that and also my motion for summary judgment be granted and opposing party be denied the right to appeal it, as their claims are frivolous based on the perpetual record that I have before the court filed on submitted to the court for the record. So motion for summary judgment can be powerful and you must know how to use it. And after that comes trial. So you have motion for discovery, which is a tricky one. I'll get into that. And then after discovery comes depositions. Then after depositions comes motions for summary judgment, if they even choose to file one, motions to dismiss, etc. After that, if it can't be decided, a federal judge could put you in arbitration if you choose, if you consent. And if you can't alleviate it through there with the mediator, it goes back to the court before the judge, and you go to trial if they don't want to settle. But it's highly unlikely. Well, it's kind of foolish. This is what gets me about attorney generals and big lawyers. You think just because one doesn't have an attorney and they serve as their own counsel, you think the federal judge is going to throw it out as if the claim was frivolous. It would have been done from the beginning when the complaint was filed if it was frivolous. Once you've gotten past discovery and depositions, you should be sweating, because that means it's a valid claim, or else the judge would have kicked it out along with a magistrate and the judge, right? So motion for summary judgment is a powerful document, but you have to know how to assert your claim, backed up by standing and foundation. Stay sharp.